Yes. Go on. What? Yeah, you were about to say something, and I interrupted you before you almost opened your mouth. What were you about to say?
I was going to inform my lord what I hope is evident, although I can't see them. Yes, it's all right. The 3 files of the supplemental unagreed bundle.
Yes.
Which is in fact substantially agreed, save by the father of them.
Okay. The point I was going to make is I think that to keep things in the right order, we should hear, to the extent that we are going to hear, from Miss Farrington now, and then you. That's all right. And I understand that you're here with legal aid, but your junior is not.
That's right, my lord, yeah.
And I'm sorry that that's the situation that has developed, because you're here at the invitation request, in fact, I think probably order of the court. So
yes.
I would have hoped that you both would have been legally aided, but...
sadly not the case, my
yeah.
lord. She's been of great assistance. As you know, I wasn't trial counsel.
Yes, exactly.
And
Well, that's
so
the reason.
To have Miss Hyde has been of great assistance. My lord, yes, as you know, I filed a written submission document, and I
Yes.
set out really the chronology there of taking instructions from the father. He's not in court today, he's
Yes.
unwell. And his position has been consistently, even through the evolution of the case, that he remains neutral. So on that basis, there's no disrespect intended to the court when direction was made for full written submission.
Yes,
or
no,
aspects of appeal.
understand.
Not in a position to do that. I have, my lord, set out some law, which I hope is of some assistance, in terms of really what the Court of Appeal can do. And perhaps if I can start with this really quite basic point, but you don't have the same evidence before you hear as the court below. And you'll have noted from the local authorities' skeleton argument at paragraph 9 that they invite you to substitute a finding on the basis of the same evidence. But you don't have that. And in particular, you don't have the transcripts of the oral evidence of the mother and of the father. And in respect of the issue surrounding the injury to the lip in the hospital, you don't have the transcripts of the evidence of the clinicians. So, in short, you don't have the same evidence. And my lord, I have cited within the position statement a case from 2009, where in fact there was a substitution.
Yes.
Which is 3D, and it's
Yes.
paragraph 28. And what?
Paragraph 28.
I've got it.
Yes.
And what is of note, in particular in that case, was that they did have transcripts of the oral evidence before them, and they noted a clear and unequivocal admission by the mother that she caused an injury. And that evidence clearly allowed them to review the findings. And in this case, my lord, I say that is not the case. You don't have that. You're not in a position to make, for instance, positive findings about the lip injury in terms of the father. You're not able to use that or come to a conclusion that he should be in the pool. And if the argument is, well, if mother is not the sole perpetrator, then it's almost logical that it follows it must be one or other of them, then as Mr. Toomey has already submitted, there's actually a variety of outcomes when the evidence is considered. And so, in short, if any of the limbs succeed, then there would have to be a rehearing. You would not be in a position, in my submission, to substitute a finding surrounding the father.
And the local authority were asking for, somewhat unusually, but they were asking for a finding that your client was the perpetrator of 2 injuries and an uncertain perpetrator for the others.
Yes.
So that's, which illustrates the point you're making.
Yes.
And the potential variety.
Variety of outcomes.
Yeah.
It's not a simple, almost kind of mathematical equation. It's a completely different situation to the case in 2009. So, my lord, we say that you cannot substitute that, and that there would have to be a rehearing. Now, I don't know if there's anything. I'm very in quite a difficult position. I'm hearing submissions, but I don't have any instructions to make any substantive submissions.
Yes.
So I'm in rather
but I do think it was important. Sorry, this has self-justification. It was important that you were here to hear the submissions, so that if anything arose that you thought it was necessary for you to address, you could.
Yes.
You still can.
Yes.
Yes. Do you have any questions?
Well, she might want to respond to this.
She might. Do you? No?
No.
Any questions? No. Thank you very much.
Thank you very much.
And particularly thank you for your junior for coming here pro bono. Yes.
Well, my lord, can I start at what's the beginning from the local authority's point of view, which is how we close the case in front of the judge? Because it's going to be plain that the judge rejected a number of the submissions that we made.
Yes.
And you'll find that in the supplemental bundle, the unagreed supplemental bundle.
The new one.
The new one.
69.
A69. My lord, this is a long document. I'm not going to take you through each paragraph, but it may help at A73, so that the court has a shape of the case as the local authority left it in front of the judge.
Yes.
We were alleging that there had been earlier, that's allegation 1.1, that there had been
Yes.
earlier occasions of bruising.
Yes.
That finding was rejected.
Yes.
On the next page, we were alleging that there were the 4 fractures which were found. Then at page A77,
Yes.
we were alleging that there had been bruising in the period leading up to the hospital admission. And on our reading of the judgment, a generalised finding was made on that. And we've already looked at a paragraph 172 of the judgment.
So the finding saw was multiple bruises on his back at least a week before he went into hospital. Yes.
Yes, it was much wider,
Yes.
a more particularised finding
No, but
that
yes.
was made.
Yes.
My lord, then, to deal with the 28th of September,
Yes.
we see that at A85,
Yes.
and you'll see from the 3 pages after that the evolution of what we were alleging were inflicted bruises in hospital on the 28th through to the 30th of September.
That's the same list as appeared earlier.
Yes.
Is it A, B, C, D?
Yes, my lord, I think it is, but that's how we had particularised it. And then finally, perhaps it's important to alight, I think my lords are clear about this, but what case the local authority was putting on the question of who was responsible
Yes.
if these were inflicted injuries.
So the judge didn't make the findings at
No,
2.1?
no, she didn't. At A95, we were saying at paragraph 5 that this was an uncertain perpetrator case, save for injuries, the bruise and the cut to the lip that was sustained on the 28th of September, if those were established.
Yes.
So I find myself making the submission that the judge's outcome was within her discretion despite my best efforts. But it's important to start at that point.
Yes.
She did reject parts of our case.
Yes.
And the question, as we see it on appeal, is the extent to which her reasoning for that was adequate, and whether the outcome was within her discretion. We say that we understand the challenge that, in certain respects, she viewed the evidence in compartments, but she was bound to because there were different types of evidence. We say that she clearly had regard to the expert evidence and the factual evidence, and she clearly weighed both those different types of evidence. She had regard to inherent probability and improbability. Specifically, because she engaged directly with the issues raised by the experts to start with about the particular presentations of injuries, or at least those injuries that she found proven in this case. That's to say, the significance of a narrow window of fractures and the significance of particular bruising as she found it on one relatively narrow window before the child was admitted to hospital. We say it's plain that the judge, in broad terms, did not believe the mother's denial. And in broad terms did believe the father's denial, certainly on matters that were relevant. And that provided the judicial reasoning as set out in the judgment sufficiently linked together those competing considerations and strands of evidence, and provided it's clear that she had regard to the totality of the evidence, this was an outcome, both on the findings that the injuries were inflicted and on her finding about perpetrator, which was within her discretion.
I'm not sure it's within her discretion, isn't it? More that it was an outcome that she's entitled to have reached.
Yes, well, I don't disagree, but she, we say, weighed up each of those compartments.
Yes.
And there's nothing to suggest that excessive weight was placed on one part of the evidence rather than another.
Yes.
Inappropriately excessive.
Yes. Can I start with the submissions on bruising? We say that the answer to the point that the judge didn't really engage with the particularity of the evidence is to be found at paragraphs 172, 173 and 174. So that's at 116 in the bundle, and I know my lords have looked at that section already with Mr. Toomey.
Yes.
These are the findings on bruising. They're built upon what we all agree was the conclusion the judge clearly reached, which was that the forensic quality of the hospital records was poor. She clearly...
Well, not universally poor.
Well, with the exception of one doctor, yes.
Which related directly to the injury, alleged injury on the 28th.
Yes. And my lord, we haven't really been through each of the body maps and each of the entries very clearly, but to explain the judge's predicament, many of those body maps, although dated, were not signed. Some of those reports did not have body maps. And some of the witnesses claimed the same body maps as their own body maps or body maps prepared when they were present. So the judge was, we say, understandably concerned about what she could draw.
Did the judge accept the evidence of Dr. Ketchrevel?
Well, my lord, I'm not sure I could say that she accepted or rejected any of that evidence. She dealt with it in a different way, which was to find, well, having found that the quality was poor, and I think my lords will have the paragraphs in the judgment from that already, she made a very general finding that he sustained bruising in the care of his parents on the eve of coming to hospital that was qualitatively different than at any other time, including in foster care.
Well, looking at the evidence for the 28th, and particularly Dr. Ketchrevel, I hope I pronounced her name correctly, why did the judge reject her evidence?
Well,
or not accept her evidence?
my lord, she doesn't deal with it, other than within the paragraphs that say, as a continuum, the record keeping was poor.
Did Dr. Ketchrevel give evidence?
She did.
Where is that evidence analysed?
Insofar as it's analysed at 137.
She's mentioned earlier.
And 128.
And 122.
My lord, yes, because Dr. Ketchrevel was the doctor who performed examinations on 2 days, 28th and the 30th. My lord, on the face of it, the judge accepted that evidence as to what she'd seen.
Well then, on what basis did the judge make the finding that she did at 174? That she didn't find the injuries in hospital on the 28th?
My lord, I ask you to read into it the next sentence.
Not good enough.
Which can only be a reflection of the fact that she had this difficulty. She had clear evidence from those two examinations and unclear evidence from everything around it. That's how we read her treatment of it. She appears to have accepted Dr. Ketchrevel, but to have found that in the vacuum of itself it wasn't clear enough. That's not the analysis that the local authority had, but that is how the judge treated it.
So not clear enough to enable her to come to any specific conclusions?
Yes.
Either as to the nature of the marks or as to what might have caused them?
My lord, the only clarity she could have is the clarity of the observation.
Yes.
But it then became important to know whether what was seen on those two occasions was something new or something old. And the bright lights of those two assessments couldn't be taken away, as we read the judgment, from the shadow of the quality of the other assessments. I hope I've not overdone that.
When she says, I do not find the injuries in the hospital, what is she referring to your the submissions you took us to earlier as to the findings that you were inviting her to make as to the one, which is it? It's 2.1a, isn't it?
My lord, I think it is.
Sorry,
2.1 at A85.
thank you. So she's saying, I'm not in a position to find that the child has sustained the following injuries.
Exactly. We read that as a conclusion that as a whole and as a continuum, the evidence was poor.
Yes.
If we look at the lip, where does she deal with the evidence about the lip?
My lord, 174. It is the next sentence, paragraph 174.
Yes, before we get to that, on and the chronology of which he goes through at 122.
My lord, it's not in at 122.
No. What is 121 is a different body map. Yes, obviously,
Yes.
different time. So 122.
But my lord, the point about
But
121 is not one to lose entirely, because that's an observation by a different clinician.
On 121.
Yes, at 8 o'clock.
At 122, the summary of what Dr. Ketchell completes on the body map is incomplete because it doesn't refer to the. Am I right? It doesn't refer to the mark on the face.
My lord, I'm just also going to turn up page 22 in the appellant's supplementary bundle, because that's where the body maps are.
Yes. 23 is the one that we're looking at, or that relates to the one we're looking at.
And my lord, the doctor's signature is on that body map. I'm scrolling back up. Not able to give you the precise page.
Okay, 23 is the body map, 29 is the letter, headed statement for the coroner. The list in 122 is incomplete because it doesn't mention the mark on the lip. And then, was there a reason why that wasn't mentioned? Something in Dr. Ketchell's evidence which led her to exclude that from the list at 122?
My lord, I'm just reminding myself of Dr. Ketchell's body map, which is at PDF 26, so paper page 22.
I think it's 20. I think Dr. Ketchell's the signed one is at 23. Or is 22 part of it as well?
I'm misreading 22 and 23 because of where the tail on the 3 is. Yes, that's.
By the way, I hope the court had the original medical records, not just.
My lord, there was a specific production issue during the course of the hearing, which required my instructing solicitor to go to the hospital
And check.
and to examine originals and to look for coloured markings on particular body maps.
Yeah.
So there was a deal of forensic attention to the quality of these records, aside from.
So it wasn't a case where important information was dropped off the bottom of the photocopy, as has happened in at least one case, in my experience. But anyway, 23 is Dr. Ketchell's.
My lord, that's the point I'm making, and the injury to the lip, if it's an injury, is marked on the frontal image of the head. It's not marked as a bruise.
In the list in her report at 29, she says L had a bruise on the left side of the upper lip, extended the inner side of the lip into the mucosa.
Yes, my lord, I think that is marked up on page 23.
As a little a spot above the mouth.
Exactly.
Yes. And then at 27, it's there again. Yeah.
Yes, it is, but 2 days later.
Yes.
And that says bruise lip.
Now, that is not mentioned again in the list, in the judgment at 128, is it?
No, my lord, but that may be because Dr. Ketchewell's name is on a body map at 1615.
Okay,
Which
so
is
that's
not what
that
we-
isn't that
which
is
is not
I'm
what
looking at
we-
the wrong book.
That's not what we were looking at.
You're right.
That's page 28.
Sorry. So 28 is what I should be looking
Yes.
at.
PDF 31.
Right.
But it's not recorded.
It's not there. It isn't there.
It isn't there.
Right. Okay. And it's not. And actually, that's why it's not mentioned. Dr. Ketchell's list of 30. And the report. Okay. So going back to 172. Forgive me for just taking time over this. 172. I do not find injuries in the hospital at 28. This is not good notice of this. The injured lip could be swollen tissue. And I note the parents also on the 30th on the ward being observed. So where does the observation about swollen tissue come from?
Judicial inference.
Inference or speculation?
My lord, I don't know whether others will. Today, I do not recall whether there was specific evidence on that. I've read this paragraph as explaining why, although she had one authoritative witness as she interpreted the evidence, she wasn't willing to make a finding in respect of that injury. But my lord, the second point I wanted to develop on this is that we say plain that the judge accepted the submission that this was a child who presented unusually in respect of what his carers took as bruises. He was a child, quote unquote, who bruised more easily in a lay sense rather than in any sense that Dr. Rose, as a paediatrician, in his opinion, was willing to recognise. So we see that that point was paid in at 173 and 174. And my submission on that is that is the judge engaging with that point.
Are there not two aspects there to the way the judge needed to deal with the evidence on the 28th? The first and primary one was, well, what could she find about the injuries? Secondly, who was the perpetrator of non-accidental injuries on the 28th? And she says she can't reach any finding about those matters, and that's fine. But does she also not have to factor in then, when considering the matter more generally, that there was evidence of possible evidence of injuries on the 28th, in respect to which the mother could not be the perpetrator, and she doesn't seem to have factored that into her analysis at all.
My lord, I agree. There's positive evidence of what appears to be bruising in mother's absence. And that's why we closed the case in the way that we did on that. What I would say by way of answer.
What do you mean by that?
Well, I mean that's why when we prepared our closing submissions, our submission was, insofar as injuries are proven to be inflicted, there isn't any reliable information to identify the perpetrator, save that on the 28th of September, the mother could not have been a perpetrator of any injury. The child wasn't in her care. So that was our analysis.
That was your summary as to what findings you were inviting to be made. But in the judge's analysis, doesn't she have to take into account firstly, she's got to take into account the sheer fact that it's less probable that two people were injuring the child. And then she has to take into account that on the 28th of September, the mother could not have injured the child because she wasn't there.
Yes.
And she doesn't seem to have taken those factors into account, as far as I can see.
Well, my lord, insofar as I have an answer for that,
yes,
that forms part of what was her approach to unsatisfactory evidence. The evidence on these points and on observations of bruising in hospital was not reliable. But she did pay in.
Well, let's say somebody's accused of perpetrating something, crime or otherwise, on a particular date, and they say, I wasn't there, I was 100 miles away, and if you look at the CCTV cameras, you'll see that I was there. And when all of that evidence is looked at, there are some vague images of somebody who could or could not be the person accused, but the judge or the jury or whoever ultimately decides that it's not sufficiently conclusive. Well, you don't just discount that and say, well, I can't make any findings about it and ignore it. You say, well, there's a case of an alibi, and the evidence on that isn't conclusive. But you don't then say, well, I ignore that there may be an alibi here.
Well, they're short sentences, my lord, but the next sentence in paragraph 174, after the swollen tissue point, is that the parents were under observation, again on the 30th. So our reading of that is that she had in mind all those points. It was, in a general sense, an improbability that the child might sustain an injury on a ward, and in the end the judge didn't make a finding to be able to determine it. But she didn't necessarily have to return to that issue on perpetrator because she'd found that the evidence was inconclusive.
Of course, Lord Hoffman memorably said, his point, which I can't quote now, it's in the usual summary of the law, which somebody drafted, that it's a binary situation, that if a court makes a finding on a balanced probabilities in family proceedings, that finding stands for all other purposes. Mr. Toomey's complaint is that the judge didn't conduct an adequate inquiry before reaching the conclusion that she did at the start of 174.
Well, my lord, I say the judge clearly had that point in mind because she didn't make the finding, and that must be why she didn't come back to it as perpetrator. And the answer to that submission lies in what view you form of the judgment as a whole. She didn't deal with it in perpetrator. I don't think that I could expect to persuade you that there's a sentence or a paragraph at the end of the judgment.
My point is this, that if the judge, Mr. Toomey could say that if the judge had carried out a thorough analysis of what happened in hospital and concluded after that analysis that the injury wasn't there or had some innocent explanation, that would be a finding which would be binding for all purposes, including the question of perpetrator. But Mr. Toomey's point is that this whole area of the case was not sufficiently examined, so that the finding the judge made should not stand. Particularly, he says, or in one respect, because of the consequence of perpetrator.
Well, my lord, I understand the reasoning. The answer, if it is an answer, is that the judge has assessed the evidence as being unclear on this. It wasn't clear. It didn't point one way or another.
Quite, because Mr. Toomey's submission is the evidence was good enough to make a finding, and your submission is that the judge found that the evidence wasn't good enough to make a finding. That's what she did.
That's what she said.
Yes.
And it is a point that she didn't come back to that in the perpetrator analysis. I can't argue otherwise.
So what should she have done on the perpetrator? If that's a legitimate finding, what do you say flows from
the absence, if there's an absence, is that there isn't a sentence or paragraph that says, like there was about social media and like there was about online research, this is a point which was, well, I'm not sure it was raised in the way that we're debating it now, that this is a point that might be raised, but it doesn't take me anywhere. There isn't a...
Was she in the light of that finding, as expressed at 174, should she have taken into account the possibility that the child had an injury inflicted by the father on the 28th?
Well, my lord, she couldn't have done, because the evidence didn't take her that way. And I say, looking at the judgment as a whole, knowing that that's how she was reasoning it, given how she dealt with these points generally, and I know there's a point about Crown and Lucas and whether that was a formulaic iteration or not, but generally speaking, if she had this point in mind at 174 for the reasons she gave, she can be taken to have had it in mind on the perpetrator analysis, even if it might have been prudent to have repeated the point at that point.
So what in particular can we read into her analysis on the perpetrator that isn't there, but you say is can be inferred.
I say you can infer that this didn't help her because she hadn't found the evidence to be, it's equivocal evidence, whether it was a bruise or not. So if she was to be expressly relying on it for identifying a perpetrator, the foundations would be unsafe. What I'm conceding is that it may have been more prudent at the end to have referred back to that paragraph in the same way that she did to passages about online searches and...
To say it doesn't help me because...
It's a fact,
Yes.
but it doesn't lead one way or another. It is the answer to Mr. Toomey's point in our submission. My Lord, moving on to the expert evidence and taking fractures and bruising and expert evidence together, I'm not sure in the time we have it's going to help you for me to take you through everything that Dr. Olsen said, but I've given you in the skeleton argument at paragraph 23, page 17 I think in the bundle,
Yes.
what the themes were from the point of view of paediatric radiology. No radiological evidence of abnormality, but that of itself is of limited value.
Yes.
Not likely to have sustained the fracture spontaneously if he had normal bones. Not likely to have sustained them himself. Likely to be inflicted. This is a witness who this witness was cross-examined hard. This is his account, his opinions, his reasoning was tested, and the judge accepted what he had to say on that. My Lord, there is one point that does matter perhaps beyond the themes. He was asked to review the images taken when the child fell off the sofa later in foster care. So this is not a case where bone structure was never looked at again. This is a case where there was an opportunity, not for a skeletal survey, but there was imaging of the knee because there'd been an incident. And that's the explanation for what I've said at paragraph 24. And we do have that report in the unagreed supplemental bundle at page E39. Well, the date matters because it's a follow-up he was asked to do during the course of his evidence. But this happened. This happened during the fact-finding hearing.
I'm sorry, I missed the page number. Sorry.
I'm sorry, my Lord. E39. If it's electronic, then it's 267.
267.
This was a year later,
Yes.
during the.
Well, my Lord, I'm not sure. When I say yes, I'm not sure that the image was taken in November.
Okay, but it's
He's reviewing
September.
an image taken in foster care.
Yeah.
Yes.
But 10 months.
Yes.
Well, a year after hospitalisation. Yeah.
That's the first strand of the expert evidence that's before the judge. The second strand is Dr. Rose. my lords have what we say about that in outline, and perhaps sufficiently to see what the themes of Dr. Rose's opinions were at paragraph 25. He didn't disagree with Dr. Alton about mechanism. On the bruise for fractures, on the bruises, localized presentation, and presentation within a window of time was not consistent with an undiagnosed bleeding disorder. Weighing that up against bruises seen subsequently in foster care, his opinion was that those reflected increased mobility. And my lord, it's at that point that I thought it might help the court to see what he said in evidence, in the transcript of his evidence about this.
Yes.
And that's in the original supplemental bundle. And the relevant passages start at 264 or electronic 247.
Yes.
Well, I'm sorry, inevitably, the iPad is slower than paper.
Which line? We have to get there.
Well, I'm just wondering if I've got the reference wrong there. 264 is. I'm in the wrong
Bottom of the page.
I think it's 244 on the type.
Oh. Okay. Well, I'm doing rather better now. I'm on the right page. I'm sorry about that. 247 electronic, 264, line 8 onwards.
What is this in chief, or is this
This was in chief with the Guardian at that point.
right? Yes. Sorry, line 8. Got it.
Well, I mainly I think because of L's age.
Yes. He deals with the number of bruises that have been sustained in foster care.
Yes.
And that starts at line 27. Perhaps it starts at line 24 is the beginning of that section. He was asked whether it was significant that there'd been overall 40 bruises in the entire time that the child had been in foster care.
Over what period?
Over my lord, I don't know. I might need Miss Gomez to remind me of that. I forget how long.
Was it the whole period in foster care up to the
yes.
trial,
Yes.
which was a year?
Yes.
40 bruises in a year.
Well, this is my cross-examination of him. And on the next page, you will see how he deals with what to expect as a presentation if there is either an undiagnosed platelet disorder or an undiagnosed clotting problem, or even haemophilia. Haemophilia wasn't in play, but the first two might have been. And so that question is at line 12, and the answer is at line 15 onwards. My lords, of course, the last sentence in that sequence anticipates the finding that we ended up with. So the final points in Dr. Rose's evidence that I wanted to draw to your attention are in father's cross-examination at 287. And you'll see the question at line 9. The witness is being pressed on the muscle.
Sorry, can you give me the page again?
Yes, it's 287.
Thank you.
Paper, 270 electronic. The question is at line 9. The answer's at line 60, line 12 onwards.
Sorry, you might say, what is that in respect of? Is that specific or is it general?
Well, the general question was whether anything inappropriate needed to have been done by a handler or a carer. And what I was taking you to was the strength of his opinion, really. That's the point I'm asking you to take from that, as to the absence of evidence to support a probable undiagnosed disorder. And over the page, he comes back to it again in the context of bruising. The question starts at line 2, and the answer starts at line 8.
Yes.
So, my lord, that was why we made the submission that, in general terms, the opinion evidence from the paediatrician was robust, as had been Dr. Olsen. And I think you know also that the same effectively can be said, and it wasn't challenged, about the paediatric haematologist, Dr. Keenan, who'd identified no clotting disorder.
Was Dr. Rose, I see on page 271, I think it's you asked him about the cut to the upper lip on the 28th of September. Was he asked any other questions about the 27th, 28th, 29th, or 28th, 29th?
My lord, I'm not sure that he was. And I don't know if that's an apt moment to look at the cases that were presented by the parents or by the appellant in particular.
Up to you.
To the judge.
Yes.
Because it touches on that point. Her submissions are in the unagreed bundle.
Yes.
And they start at A105, electronic page 109. A105, electronic page 109.
Yes.
My Lord has, if you then turn to A111, electronic 115, at paragraph 10 onwards, you've got the mother's case on bruising and fractures.
Yes.
So she's a party under no obligation to prove anything, but my Lord has a sense of the nature of the case that she was putting, which was primarily that the local authority were not going to be able to prove its allegations at all. And then I was going to come to Dr. Ellis next, but whilst we're in this document, we can see the mother's case about genetics and science, and that starts at paragraph 27 of the document. It's A116, electronic 120.
Yes.
So, possible association, limits of medical knowledge, unknown etiology, inherent probabilities. But those were the points she was making. And my Lord, our submission is that this judge did deal with all of those points within the body of the judgment. My Lord, I gave you in the Skeleton argument rather a long version of what Dr. Ellis had said. And I wasn't going to take you to things that I've said in writing already, other than to underscore this. It's plain that this was an expert who started with an open mind and whose opinions evolved. This was a robust opinion from a very experienced clinical geneticist who'd undertaken every investigation that he could reasonably identify as might be required. I couldn't prove on the basis of the expert evidence alone that these were inflicted injuries. But Dr. Ellis was just as robust in his assessment of the presentation and probabilities as a matter of opinion as the other two doctors in the end. He did say quite a lot of relevance to the genetic tapestry within which the judge was making her decision. And this isn't really referred to in the judgment, but I thought it might assist my lords to see the evidence that the judge had from Dr. Ellis orally from the transcripts, as well as what he'd said in writing before he got into the witness box. And those start in the supplemental bundle, the appellant supplemental bundle. I've got that at 180. And my lord, electronic page is 183 for that. And this is my cross-examination of the doctor. And I'm directing you really to the question at paragraph 30 and the answer which then spills over the page. So much less surprising is the submission, once one's read that evidence, that a child might have in and of itself a genetic variant. Much more important on that evidence to know whether it could be associated with a clinical presentation. He said on page 184, electronic page 187, line 2, the evidence had gone as far as it was reasonable to take it. That's line 2.
Yes.
And my lords, then at line 10, his own opinion as to how he would expect a genetic predisposition to manifest itself. That's on bruising.
Yes.
And then over the page, question starts at line 3.
Answer.
Sorry, that's the answer starts at line 3. The question starts at the bottom of the page before. This is the equivalent opinion about likely presentations in respect of fractures.
Yes.
So again, robust opinions and important evidence when the judge came to look at inherent probability and improbability, and what she made of the denials of each of the parents, who, I should say, the local authority did not allege presented as parents who were concerning, other than the injuries that have been discovered. There are other passages in the transcript, but my lord has, I think at one point the doctor says 2 + 2 doesn't equal 10, but that was a shorthand for trying to explain what I think my lords have seen just from that passage.
Was there any change in his opinion under cross-examination from
No.
Mr. Underwood?
No, nor from Miss Grief. And again, my lords know from the judgment that the judge placed particular weight on his independence and his reliability. So all that evidence goes on the first ground, which was whether these were inflicted injuries or not. There was, we say, a very robust body of evidence and an equally important line of inherent probability that more than justified the judge's findings on that issue, notwithstanding the other positives that each parent presented as individuals and as the way they were observed to interact with the child. I say that reading the judgment as a whole, you can tie those points into the judge's assessment of the factual evidence from each of the parents, and also from the maternal grandmother who was in the home at the time when the fractures were sustained, but not at the time when the bruises were sustained. And you can see that the judge evaluated those different types of evidence and didn't close her mind to either of them. I accept the characterisation of Lucas, which you see repeatedly throughout the judgment, as formulaic. It is a shorthand statement, there's no doubt about that. But I ask you to have in mind how the judge applied it on those lies which she thought were relevant and those which she thought weren't. And she did not think that a fabrication about the whereabouts of the grandmother at the time when the fractures must have been sustained. The grandmother was in the house, but there was a concocted chronology about that to put her out of it. Went to the heart of the issue. She did not think lies about housing went to the heart of the issue. And I say that's important, my lord, because that illustrates that this judge did weigh up particular untruths and distinguish them. Her conclusion in respect to the mother, we say, looking at paragraph 157 of the judgment, was that took her to the conclusion that the mother was seeking to cover up the truth. Not of itself corroboration of the mother's guilt. And so what we say in the end passages of the judgment, which again I'm bound to accept, are reasoned more sparsely than the expert evidence. That the judge weighed up those factors, but in the end, essentially what she did was accept the father's denial and reject the mother's. and that was an evaluation which was particularly hers to make. My lord, I think if I say anything else, it would be by way of putting a red line under something that you've read already, or a reference that you have already. I know my lords will ask me about outcome in a minute, but there may be other questions that you have.
Do you have any other questions?
I don't think so.
Do you have any other questions? No, then outcome.
Well, my lord, the outcome we contend for, in one sense, is unusual, but we're taking it in stages. If you set aside the findings of fact as to the nature of the injuries, then clearly this case is going to be remitted for a rehearing, and I don't think I could resist that at all. If my lords set aside the finding in respect of perpetrator, we say it is rather different from many of the cases that have come before you. The case that's identified by Miss Farrington is about an admission that's to be found in the evidence. This case is the opposite end of the scale, but it's the same principle. This is a case where both parents deny responsibility. And so, my lord, we do say that you would have sufficient evidence before you to accept the proposition that we urge you to, that it's not possible to identify a probable perpetrator on the evidence with those denials. If we don't succeed on that, then again, plainly, the question of perpetrator would have to be remitted. And it becomes a difficult exercise as to who that might be remitted to. Because
Well, can you remit the perpetrator issue by itself?
Well, my lord, it's a discrete finding.
Yeah, but it's all tied up with the rest of the analysis, isn't it?
It is and it isn't, in the sense that if you have upheld the findings in respect of injuries, that establishes a clarity, and the remitted exercise would then be quite narrow. Which is
So that would include the finding that the judge didn't make about what happened in hospital.
Well, and that's neutral, we say, and we say should be neutral if my lords are willing to look at it today. But there are practical difficulties for this case. There's a 5-day window set aside in, I did have a note at one point of it, August, in August. Otherwise, it's not at all clear. I appreciate that's only part of the matrix from this court's point of view. It's not at all clear when a rehearing would take place. There is everything to be gained from clarity.
Has the local authority finalised its care plan on the basis of the judge's findings?
Yes.
And what's that?
It is a care plan for adoption. There is an application by a family member for an assessment, which would be a challenge to that. And that will be heard at the final hearing unless something changes in the meantime.
So the findings against the father were what?
There are no findings against it.
So on what basis is the not a rehabilitation to the father?
He's not, as I understand it, seeking to have the child returned to his sole care.
Right.
So your submission is that, well, yes, I think we've got your submission.
In reality, this court has the information that a remitted court would have, or sufficient of it, to make a determination.
Right,
On
thank you.
perpetrator. Right.
Thank you. Yes, Ms. Brereton.
Well, my lord, the difficulty with going last, of course, is that my learned friend, certainly for the local authority, has made a number of submissions, which you will find, of course, in our skeleton argument, which is in the bundle.
Yes.
And so what I hope to do is to assist you perhaps further with aspects that the Guardian, through in terms of representing this little boy, would say are important. And can I start with the section on lies, which has been canvassed by my learned friend, Mr. Toomey, and indeed Mr. Vine. And one of the distinctions that we say the court can look at in this particular case is that there was a pattern of lying as found by the judge. So, of course, when one has a Lucas direction, and I don't disagree with the formulaic conclusion that has been put before you, but when one has to look at the lies, what the judge particularly found in this case is there was a specific pattern throughout, and that the issues about which the mother lied were in fact germane, they were substantial and material, and certainly probative of guilt. And you will recall, my lord, that there were specific findings, for example, about the fact that the mother had alleged during a 6-week check that she had told the doctor about the concerns for bruising, and that the doctor had said, is someone hitting the baby? And of course, the evidence of that doctor during the course of the trial was preferred by the judge. So these were issues that went straight to the heart of the mother's credibility. And that was not the only one. There was the birth process, of course. And the judge took into account that, of course, giving birth is a difficult process and one would need to consider that. And there was also, here was a mother who was presenting herself as somebody who had sought medical help for the concerns about bruising since the baby was very small. But in effect, she had not. And she had not contacted the health visitor or sought any medical appointment between June and September, which would in fact lead to a doctor taking into account and being told about the concerns for the bruising. So we say the judge went above and beyond the usual differentiation in terms of Lucas lies, if I can couch it as that, and she found a specific pattern that was only found in the mother. And of course her position in respect of the father was very different. He was a more straightforward witness on a number of issues. And so, my lord, we do ask you to take that into account when you're considering how the judge dealt with the Lucas direction, and how it has been argued that it was formulaic and didn't quite capture the difference between substantial and material lies and those that weren't probative of guilt, such as the housing, which has already been covered, and such, of course, as the deliberate lie that the judge found that the maternal grandmother, the mother and the father colluded about in respect of the grandmother being out of the jurisdiction for part of August and then coming back into the jurisdiction without anybody effectively knowing about it, other than, of course, the parents and the maternal grandmother. So that is essentially what we would ask you to consider, is that there is a pattern found here, which, of course, fed in to the judge's ultimate conclusion that the mother could be identified as a perpetrator, which of course the court should seek to do, but should not strain to do. And we say that was perfectly within her discretion. It was something she was entitled to land upon in terms of findings, having had the benefit and the privilege, of course, of listening to all of the evidence and being in a unique position to reach that conclusion, having assessed the credibility, the reliability, and of course demeanour and impression that each of the parties, the mother and the father, that is, created before her.
We don't have the evidence, do we, the transcripts of the parents?
No, we don't.
But can we assume, I assume we can, that the mother was cross-examined about about the alleged lies?
Indeed, uphill and down dale, particularly about those that I just mentioned in terms of seeking health appointments, the birth process, which of course, as you have gathered from the documents, the birth process was something that the judge anxiously considered in terms of whether that was something that could account for the fractures. So yes, my lord, during the course of the mother's cross-examination, all of those potential lies, as they were at that point, were canvassed very much in terms of A, whether she'd told a lie or not, and B, perhaps the reasoning that underpinned that lie. So that was certainly something that the judge was very concerned about, because of course the mother's case before the judge was that she had told numerous professionals about the bruising and the concerns, and ultimately she had not, and that is what the judge found. And also she hadn't told the father about various things. You'll recall that in fact Dr. Gill, who was the GP who saw this little boy at the GP surgery around the time of what I'm going to call the extensive bruising, he in fact had asked that the child be brought in on the Friday afternoon.
Is there a schedule or summary of the lies allegedly told by the mother in somebody's written submissions? I wouldn't be surprised if there was.
In the grounds of appeal, I know there were various ones that were picked out by the appellant. However, when I looked at them, there were more than those put before the court. So there isn't a specific schedule. But certainly
They
the one...
featured, no doubt, in your closing submissions, which we've now got.
Yes, indeed. So, my lord, just in terms of...
So you were just saying about the GP, you were saying adding something else.
Yes,
You finished that? Yes.
the GP on the 18th of September had asked that the mother come in that afternoon, and just to put it into context, it was that afternoon that the mother asserted that they'd seen the bruises and the photographs were taken. But in fact, the mother did not go into the surgery until the Monday, which was the 21st of September. And this was a piece of information that she did not relay to the father, i.e. that the GP had invited her in on that Friday afternoon. So we say another important, substantial material lie that led this judge to conclude that this was a pattern of lying.
So this was after, forgive me, I mean, this was after the immunisations.
That was on the 17th of September.
Is that-
And the Charles baby grow was lifted up.
Yes,
She saw
the bruise.
multiple grey-blue is how
Yes.
it's described.
That's right.
She said, go and make an appointment with the GP. The next day there was an appointment with the GP, but not face-to-face. But the GP on the telephone had said that the mother could bring the child into the surgery that afternoon. But that was a piece of information that the mother hadn't told the father. And in fact, they only went to the GP, Dr. Gill, on the Monday, which was the 21st of September.
And was that an appointment?
That was a specific appointment then that the mother and Dr. Gill had created between them, when obviously the mother had relayed that that afternoon she wasn't going to be able to come into the surgery. That is not something that the father was told, though.
Thank you.
So that's not quite lies, is it? That's withholding information from the father. That's
It is withholding information from the father. I accept that, but also
I wasn't challenging your lies. In fact, does that make it rather more substantial than a lie, or too?
Well, yes, it does in many ways, and it seems to me that it is probative again of the mother, as the learned judge said, of covering up things as well. So she was covering up things, which of course then led the judge down a path to suggest that this contributed to her capacity to find that in fact it was the mother who had perpetrated these inflicted injuries and not the father. But we say that is an important factor when the judge came to consider who the perpetrator was of these inflicted injuries. And that is something the court should take into account. My lord, just in terms of the bruising, because I know that why the court asked quite properly, did the judge not go through, as it were, the 28th, the 29th, the 30th? Why is there not more analysis of that? But of course, the judge had to look at the wider canvas of the bruising generally. And I'm not going to repeat the comments that my learned friend on behalf of the local authority made in terms of Dr. Ellis and Dr. Rose's evidence. But of course, this little boy, in terms of the weekend of the 17th, 18th of September, what the judge was able to find on the evidence was that that bruising was very extensive and was different to any other bruising that came subsequently in foster care, and of course during that window of time that you've explored, the 28th and 29th and 30th of September. And what the judge had around the specific extensive bruising finding was professionals recording very specific details of what they'd seen. So you had the immunisation nurse, Donna Tustain, you had Dr. Gill, and then of course once the child went into Bedfordshire Hospital, you then had the professionals who'd seen him upon arrival. So that enabled the judge on the evidence to indicate that that was extensive bruising above and beyond anything that came after that as part of the wider canvas, including the 28th and the 29th, but also including the bruising that had happened during the child's stay in foster care, where he still is. So we say that she was able to make findings specifically about that bruising, and of course it coincided with the potential window for the fractures. The judge was able, and she did analyse that in more depth than the 28th and the 29th, which even with Dr. Ketrevil's perhaps only record that she placed any reliance upon, it wasn't just Dr. Ketrevil, of course, who saw the child on that day. There were other people who came in that morning. Dr. Talukta was one of them, and his evidence, my lord, during the course of the trial was seriously challenged. And so I think it's not just a case of why didn't she look at Dr. Ketrevil, why didn't she go through it in her judgment, why didn't she say, well, Dr. Ketrevil, who was a good reporter, has stated all of these things, because there were other professionals around that time who were also recording the lip, for example, Dr. Talukta, who also looked at it and had a different description. So it was muddled.
So you say that we can't ring fence within the hospital admission period. We can't ring fence, Mr. Timmy might like us to do, the evidence of Dr. Ketrevil and say the judge should have relied on that, or could have relied on that. You say it was all contaminated, the reason she spelled out.
I do, and I say it was part of a continuum of bruising that this little boy had experienced from the September weekend right through to foster care, and that in terms of Dr. Ketrevil, because the record keeping was so poor, and because it was muddled, and because the judge decided rightly in my submission that she couldn't therefore say what marks or bruises were appearing around the time of the 28th, 29th, and of course the 30th, because there was a period when the father went home and there were other bruises again on the 30th of September when the mother was in fact looking after this little boy.
So in fact that brings us back to 174, how the judge put it. Albeit you've spelled it out rather more. You fleshed it out for us.
Yes, exactly. So 174 does capture it when she was faced with the evidence she was faced with across this continuum, and with all of the other professionals who also were around during that window of time and also had comments to make. So yes, well done, Dr. Ketrevil certainly found its way into the judgment, but you cannot, in my submission, bearing in mind the quality, I say quality, probably the wrong word, but the way that the record keeping was, which, as you know, my lord, led to the judge making comments at the end of her judgment about the judgment being shared with the relevant hospital in terms of future record keeping. So, in fact, it was open to her, and in fact, she was right not to specify and focus and concentrate on that particular window, even though she had the only record that perhaps was more obvious and better kept than the other records.
Your written submissions in closing were rather different on this, weren't they? Paragraphs 36 to 40.
My lord, do you have the page number? Sorry.
Yes, it's in the unagreed bundle, electronic 175. I think starts at 170. It's A170 in the
A170. Yes, I have that.
electronic 174.
And paragraph 36, my lord, you're referring
36
to.
onwards, yes.
Yeah, I mean, first of all, I can't claim that closing submission because, in fact, my junior, Mr. Barnes, wrote that, but he is sat behind me and, in fact, was there for the judgment. But I think that the difference, obviously, in terms of today, is that the judge has now made the finding she made at paragraph 174. But what we say, my lord, is it was open to her to make that finding in 174 because of the conclusion she reached about the record keeping and because of the quality or the lack of quality that was in those documents. And so what we are saying is that in terms of the appeal, it was something she was entitled to find on all of the evidence before her, including all of these records, including the evidence.
May I ask what the references to the text communication in paragraph 39 is? That's something that's passed me by so far. Suggestive of the father feeling very anxious and stressed.
Yes, I mean, we haven't gone into the social media, and there were, I think, probably about 6,000 or 7,000 pages. But during the time when the father was looking after Lucas, Lucas hadn't seen his father at that point for about a week, I think, because the mother had been at the hospital. But during the time, the father sent a number of text messages to the mother from the hospital, which exhibited a sense of stress in terms of looking after Lucas. And various other issues. So there was a communication channel between the mother and father about how he was finding looking after Lucas that evening, which I think, from memory, I'll be corrected if I'm wrong, was the first time he'd seen Lucas, or certainly looked after him for about a week.
Was anything raised of the fact that it doesn't appear that Elle was fed that night?
I haven't got the text messages in front of me. From memory, because I was trial counsel, I don't think it was specifically raised. I think it was more about he was, the child that is, he was crying, and the father was stressed in dealing with that, albeit there were nurses around on the ward. And I think that they'd heard the child cry, but they didn't intervene. That's what I recall, is that they hadn't needed to intervene in terms of the father's care. I'll be corrected if I have that wrong, but certainly the tenor of those communications, my lord, was the stress surrounding that evening when looking after the child.
Yeah. I mean, taking what the Guardian submitted through these submissions, the injury to the lip was whilst it was in the father's care. Evidence to suggest blood and bleeding occurred. We've seen that today. It was recorded in writing that the father himself pointed out there was blood.
Yes.
Then, and the other points made we've referred to. And then 40, if the injury was inflicted, could only have been inflicted by the father. Your submission then is that the court will have to consider what weight that finding has in the consideration of other injuries and the wider picture. And again, you say, or the Guardian says that the court will have to consider whether the particular circumstances are capable of wider application. I think that really, to some extent, encapsulates the debate that we've had today as to whether or not the judge approached the evidence of the 27th, 28th correctly in her overall assessment of the perpetrator in particular.
Yes, and I can see that obviously that's been a source of consideration and tension. I think the difficulty is we don't have the transcripts, but during the course of oral evidence, particularly of Dr. Ketreval and Dr. Talukta, there was exploration of whether the lip was a bruise, whether the lip was a cut, and various other things. And there were other explanations given about the child, for example, having scratched himself during the course of that. And so the judge, obviously, this was the submission at the end, but she didn't align herself to be in a position to make findings about the events surrounding that particular window of time, the 28th, the 29th and the 30th, because of the various factors outlined. And one of the things she was concerned about is that obviously the child had eczema and there were a series of marks. You may recall in Dr. Ketreval's body map, one of the things she was contemplating was whether one of the alleged bruises was a prominent blood vessel. And I think in the end, although of course that is what we were inviting her to consider, particularly that window of time, in the end she didn't reach the conclusion that she was able to analyse that in a specific way that meant she could make a specific finding that related to the father. Having looked at the evidence in the round and the totality of the evidence to which I return, which was the continuum of bruising, which was across that period and also potentially, and indeed, although there were gaps, it lasted into foster care. So she obviously did not believe she had the evidence upon which to build a conclusion or to reach the conclusion that A, this was an inflicted injury, and B, it was specifically perpetrated by the father.
The positive comment she makes about Dr. Kettravels is confined to her record keeping.
Yeah.
I mean, she wasn't necessarily criticising her, but she wasn't elevating her evidence or accepting her evidence in other respects, was she? And there was a conflict, as you've pointed out, on the question of whether it was a lip cut or a bruise.
Yes.
Dr. Kettravels said it was a bruise, whereas the other witness, who hadn't apparently dated her body map, said it was a cut.
Yes, laceration was a word in one of the body maps.
So there was competent evidence and the poor record keeping.
Yes.
And that's what led the judge to conclude she couldn't make any findings at all about it.
Indeed. And I think when a judge is faced, of course, as this judge was, with a large degree of lack of names, identification of people, it's not surprising, is it, that Dr. Kettravels was elevated to an extent because she was the only one who signed and dated the map. But I agree, my lord, that doesn't equal that she therefore adopted everything that Dr. Kettravels said, and on the back of Dr. Kettravels' evidence was able to make the findings that potentially were sought.
Which would have, yes, thank you.
Yes. So, my lord, that's what I wanted to say about Dr. Kettravels. I think I've assisted in terms of, obviously, the Lucas direction. I don't think I'm going to trouble you about Dr. Ellis's evidence because I think my learned friend for the local authority has covered the ground that, in fact, we cover in our skeleton. Again, I say we, it was Mr. Barnes that put together the skeleton argument for this court, so I certainly don't want to claim credit for that. My lord, may I just turn my back for a moment?
No.
Sorry. Mr. Barnes quite rightly points out, and at A141 into 142, this is the
new bundle.
Indeed, the one that you were discussing earlier.
A141 to 142.
Yeah.
Yes. What is this?
Well, these are the submissions about the bruising.
Sorry, whose submissions?
These are the father's, I believe. Just going to check. Yes. But at A141, 142, this might give you a picture of what the judge was faced with in terms of the conflict and the difficulties with the evidence specifically about the lip. So by the end of the trial, here we find, obviously on behalf of father, they are setting out the issues and the difficulties, particularly with those alleged injuries. By those alleged injuries, I mean the lip, and of course there were allegations around bruising. And as I mentioned, Dr. Tulukta also provided a body map, and that might give you an idea, my lord, of how muddled it all really became. And it would have been difficult for the judge, in my submission, to make findings at the end of the trial and on the way that the evidence evolved during the course of the trial.
Yes.
I mean, I think my learned friend for the local authority has covered it, but this morning, when Mr. Toomey was addressing you about the mother's position on the bruising and part of the appeal, during the course of the closing submissions and the point that you've been taken to, which is paragraph 10 of the mother's closing submissions, of course, the parents' case to the judge, or certainly the mother's, forgive me, at the end, was that the judge was not in a position to find that this was all bruising. And that was the case that was run at the end of the trial on behalf of the mother. I know my learned friend, Mr. Vine, has touched upon that, but it is an important point. It wasn't being put that the judge could make findings. In fact, to the contrary, it was being put that the judge could not find that these were specific bruises. And that was how the case was run.
In hospital, or generally?
In after. Well, my junior who was there thinks that it was put in respect of both. He was there for the closing submissions, not just in terms of hospital or after, but both. And that was the case, because what had been run during the course of the trial is that were these bruises or not? Were these marks? Were these eczema? Were these red marks that this little boy had to get? And so ultimately, what they were saying is that these were not actually bruises, and the judge wasn't going to be in a position to find that they were bruises.
Thank you. Yes, Mr. Toomey.
Well, just 2 or 3 short points, if I may, by reply. Can I just pick up on that last point? Particularly because the way in which the case on behalf of the mother is put in ground 1 is that the judge failed to find that there were marks described as bruises during the baby's stay in hospital that could not have been caused by the parents or either of them. And I appreciate the content of paragraph 10 of the closing, but it's been made very clear to me that the mother's case was that there were ongoing marks and bruises in hospital. And in fact, it's reflected in the father's submission. So the passage you've just been taken to, I think, does make it clear at A143 in the latest bundle.
Yes.
The heading that deals with the 28th to the 30th.
Yes.
I don't understand the first line because I'm not sure that's right, but no submissions are made, save to say this reflects the general pattern as described by both the mother and the father, that the child bruises marks easily and that the marks would come up and go. So that was the issue that the mother was asking the judge to address, although paragraph 10 is a much more broadly phrased paragraph. It's referring, on my understanding, to the allegations of bruising prior to hospitalisation. In relation to the 28th, what is not apparent, 28th of September, what is not apparent from paragraph 174 is why it is the learned judge discounted the evidence of a consultant paediatrician that the child had a bruise. In any event, whatever approach was taken to that, faced with a cut or a bruise, the judge comes up with a possibility of swollen tissue. But what the judge does not go on to deal with is the 30th at all, unless the reference to the parents being observed on the ward is to say that they could not be responsible for what was found on the 30th. So I just remind the court that in the first supplementary bundle, page 30 deals with the 30th, and there are a number of bruises that are listed there. And in respect of each of those bruises, appearing as they did on the body of a child 9 days by that point in hospital, they required engagement by the learned judge and an assessment. And nothing that the learned friends have said in relation to the 30th assists this court in understanding why it was that, in effect, the paediatrician's view as to what was seen on the 30th was discounted. So that's all I wish to say, if I may, about bruises. May I just say about lies? The local authority's submission to the court is that the lies were not corroborative of guilt, but allowed the judge to accept the father's denial and reject the mother's denial. Pausing there, the guardian's submission to the court is that the matters were probative of guilt. That immediately demonstrates the problem with the judgment, and in particular the judge not doing what she was required to do, which is to set out the lie, set out why it was significant, in particular why it pointed towards guilt. And in relation to the local authority's case, that it allowed the judge to accept the father's denial and reject the mother's denial, that amounts to the same thing, which is corroboration of guilt. So I don't accept that is different. If you find that someone has told a lie and you use that to support the view that what they say about injuring a child is to be rejected, you're using it to indicate guilt. There is a list of lies. The local authority did produce that, and my lords will see that from A95 in the most recent one. It's quite a helpful list. But interestingly, the guardian's approach to the mother is limited at A174 in the most recent bundle to 3 paragraphs, which include a number of significant positives, some of which I've alluded to today, and none of which appear in the judge's assessment of the mother as the perpetrator of inflicted injuries. And I think finally in relation to lies, the point made by the guardian that this is a pattern of lies doesn't assist, in fact points the other way, because the pattern includes those lies which we know the judge discounted after a Lucas direction. So where she sets out the pattern of lies, she does so by reference, and this is 179, to her own mother being out of the country and the father's position in the property. So within the pattern of lies, as it is said, she includes what we know she discounted earlier by application of a Lucas direction to be relevant to guilt, and then includes other matters. So in my submission, that makes it far more problematic that she relies not just upon 1, 2, or 3 clear lies pointing towards guilt. The pattern demonstrates a lumping in of the of the lies that did not survive the Lucas direction. And of course, some of these lies, for example, would not have assisted the mother. The Leonard judge didn't descend into detail, but for instance, that this child's mother said the child was delivered after a very difficult birth, which was incorrect about the turning of the child before birth, and all the difficulties she described, that would tend to explain why the child was fractured in the course of birth. But of course at trial, the fracture in the course of birth was something that supported Dr. Ellis in seeking an explanation, as it could point towards fragility. So describing the birth as traumatic did not assist the mother in that regard, but there's no descent into detail there. And then finally, in relation to lies, it's been the reference to the GP. As I understand it, the GP offered the appointment on the 21st. I don't see, I know it's been said that there's evidence that he asked her to come in sooner, but I don't think we accept that that's right. But in any event, in our submission, the judge doesn't deal with it in a Lucas-compliant fashion.
Yes.
Well, I think those are the points I wish to make in reply.
Yeah.
My lord, this is a tangential point, but I inadvertently misled you as to what the state of play was below. And it's important for the parents.
Oh, right.
I don't think it goes to any of the issues that you will be deciding.
Yes.
but I'm told that the father has made it clear that he would wish to be assessed as a sole carer.
Okay.
So I'd not given you that
No,
information.
thank
Sorry
you.
about that.
Thank you very much.
Well, there is one matter I should have
Yes.
mentioned. I'm grateful to Moylan Jr. He makes the point, and I make the point as a result, that if the judge was concerned about the lack of record keeping, she certainly was not in a better position when looking at the period before the child was hospitalised.
Thank you. We are going to reserve our judgment. So thank you all very much for your respective submissions. The draft judgments or judgment will be delivered in the usual way for typographical errors, and as you know, not for any other purpose. And we would hope that once you have received our judgment, you will be able to agree a draft order, but if not, we will deal with any outstanding issues on paper.
I'm grateful.
So thank you again all very much for your submissions.
All right.